And thanks for the so much feedback. And yeah, we have received a number of questions in past episodes, especially with our principal lawyer, Len Watt, on QPCC. And obviously, one of the questions which have been asked from several weeks nowadays is parenting matters. So about parenting, and that's what we're going to talk about in this episode. And I have got Amy. Great to have you today, Amy.
It's good to be here again, Pravin.
Great. So let's get into the very basic. I know some of the viewers, have been asking us in last episode when we did. Some of the viewers was asking so many questions about parenting order. What does that mean in general? So yeah, if you could just give us a quick rundown. What is a parenting order, Amy?
I sure can, Pravin. So a parenting order is really a formal reflection of what a parenting arrangements for children will be. When you separate from your partner, whether it's a wife or husband or spouse or de facto, and there are children involved, you have the option of not formalising parenting arrangements, but if you did want to, the binding option, the formal option, is to apply to the court for an order, and that order is a parenting order, and that will set out care arrangements for the children and peripheral issues that surround that, as well as parental responsibility for the children, meaning who can be involved in the major decisions for children, for example, medical decisions, educational decisions, and the like. That is essentially what a parenting order is. It is the document that will ensure that parents know exactly what is happening with their children and who is spending time with the children and on what terms.
Right, that's pretty clear. So it is a sort of instructions which is very clear for anyone to act upon. Yeah.
That's right. It is the safety net mechanism for parents so that everybody knows what is happening with their children, and that is what applies if parents do not necessarily see eye to eye in what they think should happen, and that is what the court will enforce if need be.
Right. Thank you. That leads to a second question, Amy. Some of the viewers, and we see that number of the page we are doing in such live right now. And if you are watching this from any of our Facebook or YouTube on any of the channels, yeah, just give us a thumbs up. Or if you have any questions for Amy, just feel free to write. Now, let's go to the second question, Amy. So when can the order be changed? As you mentioned about parenting order, so when can it be changed then?
So really there's two options. A parenting order can be changed if the parties to the order agree that they want to make changes. Those changes can be formalised by applying for a new parenting order to essentially overtake the existing parenting order. Or the court can consider making changes to an order if, since the time the order was made, there has been a material or significant change in the circumstances relating to the children about whom the order relates. So those really are the two times that a court will intervene and make changes to those orders.
Right. So what you're saying is it should be by agreement or by the court, isn't it, if there is any material change in circumstances, yeah?
That's right. Right.
So then the question follows, then what does material change in circumstances mean? I mean, for someone like us and a very basic, what does that mean?
There is leading case law that the court takes into account, and this is how this specific requirement came into being. So there is a case, and it's a very old case now, called Rice Asplund, and any parents who make contact with family lawyers who have existing orders and want to change those orders are likely to come across this term quite regularly. What the Rice Asplund rule is that you can't go back to court to revisit parenting orders just on a whim or, oh, I've changed my mind, I want it to look like something different. There has to be a material change in circumstances. What does that mean? It means that something significant has to have happened since the orders were made to warrant the court reopening a file and intervening again and replacing the orders with new orders. Now, that could be a situation where a child or children have been exposed to a sort of risk factors, and those risk factors must be significant. For example, if it becomes apparent, and I've had inquiries along these lines, if it becomes apparent that a child is in an unsafe environment due to mental health issues being suffered by a person in the household or the other parent, or if there is exposure to drug use, that can warrant a material change in circumstances argument being successful. Other examples may be orders may be made when children are very, very young, and it's more appropriate for a very young child to perhaps live predominantly with one parent and spend time with the other parent. However, if it's been some time since those orders were made, and for example, the first order was made when a child is a toddler or very not school age, and several years have passed and that child is now attending school, and the circumstances have changed because they have become older and are more mature, that may itself meet the threshold of what a material change in circumstances is. Material change is very much dependent on the case that is before the court at that time. What is a material change in your particular circumstances may not be a material change in other circumstances. Right. For that reason, it is really important to seek that legal advice about whether or not you would meet the Rice and Asplund threshold in your particular parenting circumstances. And I'm regularly having inquiries with clients contacting me to ask whether or not it would be appropriate to revisit their particular orders. And given the current climate with COVID-19 as well, I think it's incredibly important that people do explore all options and obtain legal advice before simply deciding, I think I'm going to file court proceedings, because if you do not meet this threshold, and the court will not intervene in your matter, and so it's important to seek preliminary advice to see whether or not your particular circumstances are appropriate and you meet the threshold of significant or material change in your particular circumstances.
Right. Thank you, Amy. That's very interesting. You say that, obviously explaining on the Rice and Asplund rule. So I hope that's give a bit of clarity to our viewers. But obviously, if they have any questions, they can get in touch. We'll come to that. Now, we see that we are again live on a number of the platforms in Facebook and YouTube, and a number of the platforms. And if you are watching this right now, I am with Amy Chesnutt, Senior Associates from Matthew Love Family Lawyers, and a proud division of Becker Watt Lawyers. So now I'm conscious with the time, Amy. Let's talk a little bit about pitfalls. What are common pitfalls in parenting matters, Amy?
Probably the most common one that I'm encountering at the moment is clients contact me and assuming that because they're not happy with their orders, that the judge will relook at it. I've had, even over the last maybe 2 weeks, multiple inquiries where people have only recently obtained orders, as in 2020, and have thought, actually, I'm not quite happy with this particular order, or no, I want to completely change the care arrangements. And that seems to be a common theme at the moment, and it is really important to understand that when you obtain that final parenting order, it means exactly that. Your matter is finalised. The court will not reopen a matter on a whim. It must meet that Rice and Asplund threshold before a court will entertain another application being made. So it's really common, I've found, for people to just assume that I can change an order relatively easily. That may be the case if a party and the other person who is involved in the parenting order agree. However, if there is no agreement, as I keep saying, that threshold must be met before the court will reopen or your matter will be allowed to be relitigated. Other common pitfalls in parenting orders I found are not having your orders reviewed before you've submitted them to the court for approval by a family lawyer or somebody who is well versed in the requirements that these orders must meet, and ensuring that the orders are drafted in a way that one makes sense to everybody so that we are not talking at cross purposes or there is some confusion about what a particular order means. And it's really important that I think that when these orders are prepared, they are drafted in a format that allows it to be easily enforced if there is a disagreement and parties do not quite see eye to eye with how a particular order is supposed to be enacted. So those are really the most common mistakes that I'm encountering at the moment, and
Right.
those are I have multiple matters on foot where we are essentially going back and trying to correct, not mistakes, but correct the gaps that weren't dealt with in the original orders in the first place.
Right. I hope that's pretty clear to the viewers right now, because obviously what you're saying is assuming that you can always go back to the court if you're not happy, and that's where a lot of the common people's are. That's a common thing people think about, isn't it? So now that's a great insight, Amy. So yeah, those viewers who are watching this right now and number of our prospects and clients, what do you suggest? What is the best contact if they are on this? If they want to know more about parenting orders, especially this, this time COVID-19, what would they do?
The best way to contact us, Pravin, is to just pick up the phone and give us a call.
Right.
My best contact number is 07 3390 2344, or we have our 1300 number as well, which I think
Right.
on the screen, 1300 at legal.
Yep.
Both of those numbers work fine. Obviously, the 07 number is our local Brisbane number, so for our locally based clients, that would be the best way to contact us. But I do also deal with quite regularly interstate matters as well. The alternative, if you're not comfortable calling at first instance, is to send me an email. My email address is amy@matthewlove.com.au. If we are not picking up the phone, we are always reading emails. So happy to take inquiries on both of those forums, Pravin, and hopefully assist where people need assistance.
Absolutely. Thank you so much, Amy. I hope this has helped our community to understand a little bit more on the parenting orders. Obviously, situation is very different, and yeah, especially COVID-19, the insights what you have given us is very helpful. And thank you so much, Amy.
You're welcome, Pravin. It's good to see you again.
Likewise. Thank you, Amy. Great. So thank you, guys. I hope you enjoyed the Talking Legal episode today. And yeah, look forward to getting your feedback. And if you like this video, feel free to give us a thumbs up or share or comments. And we will see you in the next one. Bye for now.